Fourth Circuit today. We've got a full day on a Friday, but we'll start with our first case, 244251. Manita?
Manita, yes.
Manita. Ms. Manita, we're happy to hear from you.
Good morning. May I begin?
You may.
May it please the court, counsel. I'm Lana Manita, and I represent the appellant Melvin Canales Saldana. This appeal arises from a multi-defendant racketeering case that was tried over the course of 2 trials before the Alexandria Division of the Eastern District of Virginia. The case focused on the activities of the STLS clique of MS-13 and specifically 4 total murders that were attributed to this clique and various members of this clique. These appellants in this appeal, Mr. Andrade Rivas, Mr. Aguilera Sagastizado, and my client, Mr. Canales Saldana, were tried first, and another group was tried in a separate trial. This trial went at a very accelerated pace, even for the rocket docket, and at the close of the case, Mr. Canales was convicted on all counts except for the 924C charge. Most of the charges for which he was convicted surrounded the murder of ELT, Mr. Tate, who Mr. Canales did not know, never met, and took no part in killing. The evidence showed at trial that Mr. Canales, as a superior member of his clique, had ordered fellow cliquemates to seek out chavalas or rival gang members. And then the rules dictated a particular procedure, a process that should be followed after a clique member believed he had identified a rival gang member. And these steps were supposed to be followed before there was any killing. Mr. Canales, according to the evidence at trial, also told his fellow clique members to take a gun with them when they went to patrol, is what they call it, patrol for rival gang members. So to the extent there was a conspiracy to which he, in which he participated, it was to follow a prescribed course of specified steps in, with an aim and an intent of eliminating rival gang members from the streets. In this case, lesser ranked members, lower ranked members of his clique, either, and this depends on which witness's account of the shooting of Eric Tate that one believes, they either, while patrolling, encountered Mr. Tate and were suspicious of him, or they were shot at by Mr. Tate first. 2 different witnesses have given 2 different accounts, but we do know that Mr. Tate fired a number of bullets. However, he was killed in this exchange of gunfire. Mr. Tate was not a gang member. He was not a rival gang member. Generally speaking, the most prominent rival gang of MS-13 on the streets in Northern Virginia is 18th Street. It is another Latin American gang. Mr. Tate was unknown not only to Mr. Canales, who again was not present for the shooting, but was unknown to the individuals that were fellow members of the clique that he encountered on the streets that night. Even if this was not a self-defense situation and Mr. Tate did not fire upon these young men first, and I'll note again to the court that there was an acquittal of one of those clique members, it was not a shooting that was conducted according to the procedure and the rules that are set out for MS-13 and specifically for this clique, and specifically according to the evidence at trial by Mr. Canales, who admonished fellow clique members that they should do things right, that they should follow the rules. So by all accounts, Mr. Canales did not share the objective to kill this victim. He did not have the intent to kill this particular individual. This particular individual did not meet the conditions of any sort of category of individual that Mr. Canales had ordered other clique members to seek out. And so the conviction on conspiracy should not stand. Likewise, for aiding and abetting, he did not instigate, plan, or aid others with the intent that Mr. Tate, or even a category of individuals into which Mr. Tate would fit, would be killed by his fellow clique members. He therefore should not have been convicted of the conspiracy to commit that murder, nor should the special finding on count 1 have applied, nor aiding and abetting. Now, Mr. Canales' actual order to the clique, what they should be doing, looking for Travalas, the fact that he did not order Tate killed, that nobody knew Mr. Tate, that he was not a Travala, was not a rival gang member, and that the rules, in fact, did not support the killing of Tate, that it was really a violation of the clique rules, was confirmed by witness Molina at trial, and his testimony was stricken. And the striking of his testimony was a remedy that was inadequate and ultimately highly prejudicial. It was a remedy to a Brady violation at trial. Compounding the problem.
Did your client join in the Brady motion?
We did not seek a mistrial. We did not. Mr. Aguilera sought the mistrial. The court sort of gave us options of what we should do with very little time to make that decision. Again, I think the accelerated pace of this trial is notable because this was another example of having to synthesize days of trial very, very quickly to make a decision on the spot about what was the best remedy after the Brady violation was noticed. Obviously,
Judge Quattlebaum's tried a few cases. That's sort of like what being a trial lawyer is?
yes, except this was a really unique situation.
I suspect every trial lawyer would say that every trial they tried was a unique situation, right? That's sort of a common line. It'd be an odd situation for us to say, you know, if you failed to raise an objection, well, this was a complicated case. Seems like a fairly large loophole to the obligation to actually advise the district court.
Well, I understand, Your Honor, and, you know, from our perspective, we feel that the ends of justice would apply for Mr. Canales. But Mr. Aguilera did seek a mistrial, and had that been granted, that would have inured to the benefit of the other defendants, and that was denied.
Well, but the court wouldn't have had to grant the mistrial for everyone, right? So oftentimes, sort of somewhat commonly, we will have mistrials granted with respect to one defendant and not to others.
The court would not have had to, but I think given the scenario that we're dealing with, that this witness had testified against all of the defendants, and the effect of his testimony and the effect really of the Brady violation was sort of equal across all defendants, I think it's highly unlikely that the mistrial would only have been granted for Mr. Aguilera. The district court noted that
Can I ask a slightly different question? On appeal, you assume, for purposes of your argument, it seems to me, that there was a Brady violation? You're not arguing that there was an error because the district court should not have found a Brady violation and therefore should not have stricken the testimony at all?
No, I'm not arguing that, no.
Can I ask you a question that you've kind of, where we are now gets to this striking of Molina. I'm more interested or less interested in, for purposes of this question, in the decision to strike Molina as much as the challenge as to why the court struck Molina. As I understand this,
Yes.
that it was stated that it was for credibility reasons. Assume, for the sake of this question, I think that was an error and that it was plain. Could you address the other prongs of plain error review with respect to that issue?
Well, Your Honor, there was certainly prejudice. The court, and this was my next point that I was going to be getting to, this compounded the problem, because when the district court told the jury that the witness was being stricken because he was not credible.
Yeah, I don't mean to tell you how to answer the question I asked. I mean, I understand the argument that gave the impression perhaps that the other witness was more credible. That's the argument. But drill into prongs 3 and 4 of plain error review and give me your best argument as to in the scheme of this entire case, how we have that there.
Well, Your Honor, it also encroached on the sole and exclusive providence of the jury, who is charged with determining the credibility of the witnesses, and therefore really eliminated what I would consider the defendant's rights to a trial by jury on that issue. And that is a significant prejudice, especially to Mr. Canales, because that witness gave some exculpatory testimony with respect to the points that I've raised before, with no knowledge of the victim and the rules that were not followed by MS-13. And importantly, it wasn't even true. That is not why the witness was stricken. The witness was stricken because of Brady violation. So the ruling caused prejudice only to the defendants, really protected the government, and Brady is intended to protect the defendants. And in making that ruling and in instructing the jury, by doing so, it really it bolstered Blue significantly, and it really countered or contradicted the instructions to the jury that they were the sole finders of fact and the sole decision makers with respect to the credibility of the witnesses. And so, obviously, and I think I argue this in my brief, the jury goes into the jury room thinking, well, if the other witnesses were not credible, they would have been stricken also. So we're gonna take what they say wholesale. And obviously that's not only prejudicial because of what those witnesses said, but it really eliminates the jury's consideration, and that is what is guaranteed by the Constitution. And I think that we see that there was confusion. We can only speculate, but the verdicts were wildly inconsistent, not just between the defendants, but
doesn't that suggest that they didn't just accept all the other witnesses as credible?
well, I don't know. I think it could.
That's sort of the challenge with inconsistent verdicts at some level, is that like we treat them as a black box for a reason. We don't know whose ox is being gored, as the court sometimes says.
I think if they made sense as to each individual, perhaps we could say that that's what was happening, but I think it reflects more a confusion on the jury's part, which would make sense because they were really pulled away from their credibility finding by the court's comments about Molina. I think that these verdicts just don't jibe with one another, to be quite frank, and I think it really reflects confusion. And I think I'm out of time.
Thank you, counsel.
Thank you.
Wait, which order are we going? Do we go to Mr. Bodner? I believe you're next. Mr. Blanchard, we'll get to you, I promise.
Good morning, Your Honor.
Happy to hear from you. Tell us first who you're representing, and then happy to hear.
Certainly, Your Honor. My name is Mark Bodner, and I represent Manalester Andrade Rivas.
Okay.
And, of course, he is a co-defendant, counsel you just heard. So my focus, very frankly, this morning is towards jury instructions supporting Count 9 and, to some extent, Count 1 of the second superseding indictment, which was a jury instruction on conspiracy to commit murder. The court gave the government's proposed instruction 54, which we did comment on, and we offered an alternate instruction, and my co-counsel, who you just heard from, made an explanation to the court that the court's giving the instruction on first and second degree murder was to give some confusion or to lay open the possibility for confusion of the
But
jury.
a very different argument than the one you're making now, right? You didn't make the argument that by virtue of a conspiracy, premeditation is supplied effectively, right? That's the new argument you're raising on appeal. Help me understand why, we have a very good district judge.
Yes.
She hears an argument, and I understand that argument too, right? That there wasn't really evidence put on that would support a second-degree murder charge. I understand that argument, but the argument you're making on appeal is that it's like legally impossible to have a conspiracy to commit second-degree murder.
And I will concede that that precise argument, as Your Honor put it, was not offered to the trial court. However,
It wasn't made, as I recall, the comment was made that the charge that was given was legally sound.
there was that concession at one point as well, Your Honor.
So are we here on plain error then?
Well, if
I
that's
guess it's a question of law.
If that's the court's position, then the way you read the record, then it would have to be plain error. And I am here today to urge the court to consider otherwise.
So then what do I do? So when I look at various state courts that have addressed this, the Commonwealth of Virginia permits a conspiracy to commit second-degree murder. California does not. There are a variety of options among the states as to whether the conspiracy provides the premeditation or whether you can conspire to commit an assault in some way that ends in a murder that counts as conspiracy. But it seems like the cases are all over the map. And so how do I find plain error there?
That the better reasoning is that it's not logical to conclude that somebody can commit conspiracy to commit second-degree murder because second-degree murder does not require premeditation. And if you
So
follow...
what do you do, like Virginia doesn't follow that rule,
If
right?
you
That's
follow-
California's rule, I get it, right? But Virginia doesn't. Like how do we say that, this court, applying Virginia law, committed plain error in a world where like the state courts permit the very thing you say is so-called illogical?
Well, you look to the reasoning of the decisions, and I don't know that Virginia has met this head-on. At least I didn't find a Virginia decision that...
No, they haven't discussed it, but they permit it, right? I mean, we have a number of examples where convictions occur and they are upheld by courts of appeals.
This court, having been presented with the issue now, can follow the reasoning of California and the very well-reasoned Mitchell decision from our sister state in Maryland, indicating that it doesn't make sense that somebody doesn't have the intent to commit murder. However, they decided in advance with their conspiracy.
What do you do with the example that says, we have entered an agreement that, we're going to go confront Judge Quattlebaum, and if Judge Quattlebaum doesn't give us what we want, we're going to beat him up real bad. And there's an agreement reached to that effect, and then, we show up and Judge Quattlebaum doesn't give us what we want, and so we beat him up real bad, and in the process, we kill him. So we had malice, right? We had an agreement. We didn't have premedication, which in Virginia requires an intent to kill. We just were going to beat him up real bad. But in the process, he is murdered. That seems like a conspiracy to commit second-degree murder.
Well, the way I read the decisions that we cited in our brief, and to the effect that even a degree of recklessness that results in a murder subsumes that idea of premeditation. In other words, you approached this and you knew something bad was going to happen. As opposed to...
But that's not intent to kill under the Commonwealth's law. The Commonwealth says premeditation requires intent to kill, right? I mean, that's just Virginia's law.
Absolutely.
And the hypothetical I gave, there's no intent to kill him, I'm just going to beat him up real bad.
Your Honor is correct.
Okay.
My time is up. If you
Thank
don't
you,
have any
Counsel.
other questions, I'd ask you, notwithstanding what we've heard this morning, to consider reversing the convictions on counts 1 and 9. Thank you for hearing.
Thank you.
Thank you.
Now, Mr. Blanchard.
Apologize for being overeager, Your Honor. May it please the court, John Blanchard for the United States. The government's asking this court to uphold the jury verdicts returned below because the jury was properly instructed on the law, because the defendants in the case received far more relief than they were entitled to by circuit precedent, and because the evidence against them was not just sufficient, it was overwhelming.
Counsel, could you, on the point we were just talking about, not so much on the plain error part of it, but just was it wrong to charge conspiracy to commit second-degree murder? And if, well, just answer that, if you could address that first, please.
No, Your Honor. If I may, the argument that counsel referred to about not wanting an instruction on second-degree murder, that actually didn't come up on the Vicar conspiracy jury instruction. They were arguing for purposes of count 1, the RICO conspiracy count, and for the substantive Vicar count, that our theory of the case, that the evidence didn't support a theory of second-degree murder. My review of the record shows that the Vicar conspiracy jury instruction that made reference to both theories of liability, that was a joint proposed instruction. But to answer your question, Your Honor, the statute simply requires conspiracy to commit murder. Virginia law defines murder very clearly, and there's a statute that basically codifies the common law and provides different degrees for purposes of how to mete out punishment.
So you think if people, the example Judge Richardson gave, if the conspiracy was to beat someone up, that was the plan, we're going to beat someone up, but that's all we're going to do. We're going to be real clear. We're going to say we're going to beat him up, but we're not going to cross that line and risk that he dies. That's but it's foreseeable that could result from that act.
Mr. Bodner, if you're going to whisper, you got to do it a little bit quieter, otherwise we can't hear counsel up here.
I apologize.
Thank you.
Your Honor, for what it's worth, I do not believe that would be conspiracy to commit murder. I think that would be people conspiring to commit an assault.
Right.
But I do not believe that if the object of the conspiracy is physical harm but not death, then that would constitute conspiracy to commit murder under Virginia law. No, sir.
Well, but is the extension of that argument that what you that you must I guess the argument is that second degree murder doesn't involve premeditation, and conspiracy includes premeditation. Yeah, is there any problem with that?
I think it suggests that premeditation, I can see the doctrinal tension there, but really what conspiracy requires is the voluntary joining of an agreement to commit the actual crime, whereas the difference between first-degree murder
Beforehand,
and
though.
murder.
Beforehand, right? Premeditation means they have to do so beforehand.
Absolutely, Your Honor. Yes, sir.
And so if they've entered a conspiracy, if you concede that the conspiracy to commit assault that results in death is not conspiracy to commit second-degree murder, I think that concession is legally wrong, so I don't think it matters. But then I think you are conceding to Judge Quattlebaum that this instruction was legally erroneous.
I do not believe it was legally erroneous, Your Honor, and that's because under Virginia law, the Virginia conspiracy statute simply provides that a conspiracy to commit a felony is an offense. Murder is a felony. It is common in the Commonwealth of Virginia to charge murder, conspiracy to commit murder without specifying a degree. So I think the notion that if there's a possibility that a jury could have found that there was a conviction on the theory of conspiracy to commit second-degree murder, I disagree with that, because you can charge conspiracy.
So what do you think the evidence is? Like what evidence was presented that would allow a jury to so conclude? Right. So what?
Oh, Your Honor, to be clear, I believe this was first-degree murder.
No, but if you're going to offer a jury instruction, then you have to have evidence to support that jury instruction, right? And maybe you went on plain error, but like, did the government present any evidence on which a rational jury could have found conspiracy to commit second-degree murder?
Well, Your Honor, I think so.
Tell me what that story would have looked like. If you had to make the argument for why this was a conspiracy to commit second-degree murder, tell me what facts you would rely on.
Well, Your Honor, the facts were that when they went to the apartment complex.
What was the agreement? Start with the agreement, right? If you're talking about a conspiracy to commit second-degree murder, we have to start with the agreement. What was the agreement? Who was it among?
The agreement was to commit murder. The agreement was among Melvin Canales Saldana, Manny Lester Andrade Rivas.
Okay. And then they went and followed through on that agreement.
They did.
Okay. And so tell me how that lacks premeditation.
And I misunderstood the question, Your Honor. I thought the court was asking, is there a theory wherein the jury could have found that that one of the defendants committed second-degree murder?
No, they committed conspiracy to commit second-degree murder, right? The question we have on count 9 is not whether they committed second-degree murder, it's whether there was a conspiracy to commit second-degree murder. And what I'm asking you is, was there an evidentiary theory? Did the government put evidence on that would have allowed a reasonable jury to find a conspiracy to commit a second-degree murder?
I don't know the answer to that, Your Honor. I think the evidence that we presented was established that there was a conspiracy to kill. I believe that it showed premeditation. I can't guess what the jury inferred from the evidence and why they made the findings that they did with respect to the...
But you understand that when the government offers a jury instruction with a legal theory to convict and take somebody's liberty away, they must have an evidentiary basis to do that. That is their obligation. It's the court's obligation to get it right, but it's the government's obligation to not submit jury instructions on theories for which they have absolutely no evidence.
I still believe that the jury instruction...
You have just told me that you do not have any evidence to show a conspiracy to commit second-degree murder.
I believe it was a correct statement of the law that was given to the jury, Your Honor.
And by that, you mean we gave a correct theory, a correct legal statement for which we had no evidence, right? You could have asked the judge to instruct this jury on a question about wire fraud, right? You could have given a wire fraud instructions. No evidence of wire fraud, but you can just throw those instructions out even if there's no evidence to support it. That's the government's view, that they're not bound by the evidence when they offer jury instructions. That's a remarkable proposition.
Your Honor, the government offered a correct statement of the law with respect to the count that
for which it had no evidence.
We believe that the evidence that was presented in the case showed that there was a conspiracy to commit murder. Again, we believe it's within the purview of the jury to determine whether that was first degree or second degree. I can't come up with a factual scenario, Your Honor, where someone could conspire to commit second degree murder. I concede that.
I want to go to a different issue, the one I asked your colleague about, which was the not the decision to strike Molina, but the rationale given to the jury to strike Molina, that Molina was not credible. That seems wrong. That seems like that wasn't the reason Molina was struck. Do you agree with me there?
Your Honor, I do. In looking at
You agree with me?
I do, sir.
Okay.
I was confused by it below. There is some evidence in the record. Mr. Andrade's counsel argued that the tip that was provided after Mr. Molina had testified cast his credibility into doubt, and counsel joined his well-reasoned arguments. However, it appeared that it was in fact, his testimony was in fact stricken as a sanction.
That's what I think we would review that for plain error too. I don't think that was, that issue was preserved. So let's assume that it's an error and it was plain. Do you have a position as to whether it was prejudicial or satisfied the fourth prong of the Alano plain error?
Your Honor, certainly we do not believe that it was prejudicial. If this was plain error, the defendants can't show prejudice. The remedy that they were provided with, the striking of Mr. Molina's testimony, absent a finding of bad faith by the court, it exceeded the relief that they were entitled to by circuit precedent under Sterling. I would say that the benefit to the defense, as Judge Brinkema found, his testimony she found to be extremely incriminating. She found that it was a huge benefit to the defense having his testimony stricken. I think that the
It's a
argument...
pretty severe sanction for the state for what was not given to the defendants. I'm not saying it shouldn't have been given, but given what they had and what additional information it provided, it's a pretty severe sanction. So that's your point, right? That it's a severe sanction. If it had any, it sounds like there's an argument that there's certain things he would have said that might have helped certain defendants, but...
Yes, Your Honor. Our position is that certainly the preferred remedy under the precedent of this circuit would have been a continuance in the scenario that we were faced with, or the court could have fashioned alternative relief. We believe that the defendants received essentially a cure to the purported harm in this case, in which they were far better situated than they would have been. So to say that striking Mr. Molina's testimony was prejudicial, I think falls flat. They essentially make 3 points. They say that it failed to remedy the prejudicial effect of his testimony, and as we've noted in our filing, he was one of many witnesses. His testimony was largely consistent with that of Mr. Guevara. And I think most importantly in this case, you can show that her instruction was in fact given. Mr. Molina testified that Manny Andrade and Cristian Arevalo were the ones who shot Mr. Tate, and that, that's how the situation played out, and yet the jury still came back not guilty on Mr. Andrade. So I think we have kind of a remarkable scenario where not only can you see that there was an instruction that was given, but there's certainly evidence that they disregarded Mr. Molina's testimony, because without that, they were left with Mario Guevara's testimony that Mr. Arevalo had told him Mr. Andrade grabbed him and said to wait or stop before the murder. I think the argument that the jury must have found self-defense to have acquitted Mr. Andrade is incorrect. I think that certainly, just as was the case in a prior RICO case that this court heard, they could have found that he agreed to commit the murder, but did not participate himself. So certainly I don't think there was prejudice that can be established on that prong. The arguments that, well, he had things that were helpful to us that we wanted to emphasize in closing, all 3 of those arguments were still made. The fact that there were no calls between Mr. Canales and Mr. Guevara, the fact that Mr. Guevara was a rogue member prone to random acts of violence, and that Mr. Canales did not say to kill unverified chavalas, those were all made during Mr. Canales' closing. And certainly to the extent that there's an argument that Mr. Guevara's credibility was bolstered by striking Mr. Molina's testimony. Mr. Guevara's testimony, if anything, there was basically a spotlight shown on it by the judge saying this is an accomplice who should be treated with more care. His credibility or his testimony should be treated with more care. She gave an instruction about convicted felons. So those 3 reasons are really what they're standing on for prejudice, and we think that they were far better situated than they would have been had his testimony not been stricken, and had the court declared a mistrial, we could have presented new evidence. This happened after the government had already rested, so we do not believe that there was sufficient prejudice that would warrant relief under a plain error review. To the extent the court has further questions, I'm happy to answer those. Otherwise, I appreciate Your Honor's time, and I'm grateful for the opportunity to appear here today.
Thank you, counsel. Happy to hear from you in reply.
Thank you. Well, we agree with Mr. Blanchard that the conspiracy to commit murder requires an intent to commit the actual crime. But the actual crime here is not just the act of murder, be it first or second degree, I'll leave that to the side. It's the crime that is charged is the killing of Eric Tate. And so the intent to kill that victim needs to be there for the conspiracy, and it simply was not there. And the example that Your Honor gave, that if the conspiracy was to commit an assault against your colleague and then it turned into a murder, that's a different scenario than we have here, Because in your example, there's
But the challenge, and this is your colleague's argument, but the challenge is, there are two possible challenges to count 9. One is to say the government put forward a legal theory for which it had no evidence, right? That is an argument, maybe was raised below, but is plainly not raised on appeal. That argument might well have like underlying merit. There's a separate argument that says, as a matter of law, there can be no such thing as conspiracy to commit second-degree murder, right? That's the argument that's made on appeal, and that argument seems wrong, not because of the facts of this case, but because of the Commonwealth of Virginia's law, and in contrast with other laws like Maryland and California that just take a different view, so we don't have a plain error situation. They're just two separate arguments. One was made below and lost and not raised on appeal. One was not raised below, but is raised on appeal and has like a legal flaw. But neither of those are, you can't combine the facts and the law to create a hybrid claim.
Yes, I understand, Your Honor. And I'm more addressing Mr. Canales' Rule 29 on the conspiracy and the aiding and abetting because of the lack of the intent to actually kill this victim. And I'm out of time unless the court has any other questions. Thank you.
Thank you, counsel. Several of you, of course, are court-appointed, and particularly in the nature of this trial and the appeal. We thank you very much for your service. We'll come down and greet counsel and proceed to our next case. Whenever counsel is ready, we'll proceed to our next case, which is 24-4308. Ms. Donovan, we're happy to hear from you.
Thank you, Your Honor. Good morning. May it please the court. The government deprived Mr. Arevalo of a fair trial by repeatedly interfering with his access to favorable evidence, including through the deportation of a material witness and through failure to preserve evidence that was favorable to him because it supported his theory of defense. That, standing alone, is grounds for reversal. But it is not standing alone, because also in this case, at the very end, when Mr. Arevalo had rested his case, had already delivered what the district court called a very strong closing argument, co-defendant's counsel rose and gave an argument that the district court correctly found to be way beyond the bounds of an appropriate closing argument. Under these circumstances, this court should have no confidence in Mr. Arevalo's convictions.
So your second argument is that the jury disregarded the instruction given by the district court to not consider the closing argument?
Your Honor, I have two main points about that. The first is that we should look at what the court itself said months after this trial. Months after this trial, when Mr. Arevalo filed his motion for a new trial, we were before the district court, and the district court continued to express real concern that the jury had considered this information through expressing concern that this case should be reversed.
So is your argument, though, it sounds like your argument, is yes to my question? Or your answer to my question is yes?
Yes, Your Honor, for two reasons. One is that the law recognizes that there are certain circumstances under which it is impossible to believe what is essentially a legal fiction, which is that juries always follow the instruction not to consider evidence. The main context, of course, in which the United States Supreme Court has considered this issue is Bruden. And I think Bruden is instructive because in Bruden, the issue is the defendant's inability to cross-examine an accusatory statement of a co-defendant. And the United States Supreme Court said in Bruden, in certain circumstances, information is so prejudicial and the stakes are so high that we're going to set aside this general presumption that juries can follow cautionary instructions.
But here it's not an issue of evidence, it's an issue of an argument. And is there a case that you can cite where this court has found that an instruction to the jury to disregard argument was not followed by the jury?
No, Your Honor, but there's also not a case where this court has dealt with a closing argument that was inappropriate almost from the beginning and wholly out of bounds.
Why did we say that? I mean, I understand the district court found that, but what about it is so wholly inappropriate? I guess, help me understand why you think, yes, the defense lawyer did some vouching, which, surprise, surprise, right? This is like a common thing. It shouldn't happen, but it happens in lots of closings, sometimes unintentionally. Yes, there was some suggestion of facts not in evidence, why the defendant didn't testify and the like. So maybe there's some questions about facts not in evidence, but those happen in like virtually every trial that goes on in federal court. And so what about it that you thought was so bad? It was like the comment on the evidence that was actually introduced? But
No.
that seems like a very plausible thing for a lawyer to do.
Your Honor is missing the two things that I think were most prejudicial about this closing argument. The first was the discussion of Tercios's decision not to testify, in which the...
But that may be, I'm sorry.
Yeah, no, go ahead.
That may be inappropriate. It's essentially talking about decisions a lawyer made with counsel. It seems like it's,
Facts not in evidence.
Yeah, and privileged facts not in evidence. But in terms of prejudice, I mean, I'm not understanding how that. It seems like your argument is that suggests your client speaks, good English and nevertheless, didn't testify for some, maybe other reason. I'm not following that argument.
Absolutely. The comment was that Tercios Villatoro did not testify because he had only a grade school education and he does not speak English.
Right.
There was evidence before this jury that my client does speak English. The implication of Tercios's argument was there is a good reason for Tercios not to testify. In contrast, my client, who doesn't speak English, or who does speak English, had no good reason not to testify. But
No, go. I'm sorry, I didn't mean to suggest I was interrupted.
No, Your Honor has actually put your finger on something that I think is even more important and flawed about this argument, which is that it did suggest something not in evidence, the story that counsel had heard from Tercios Villatoro, because counsel specifically said, we made the decision that I am going to tell Carlos's story. And Carlos's story then became that Blue, Mario Guevara Rivera, and Christian Arevalo Arias were the killers. And repeatedly
But there's some evidence for that, right? Like, that's not like made up out of whole cloth. I mean, there's some evidence from which a reasonable person could have told that as based on the evidence, right? I mean, you can't say there was no evidence to support that theory. I get the theory's not a good one, but there's not no evidence to support it.
First of all, that's a prosecutorial argument, and that's the problem here. It's the prosecutor's job to argue that there's evidence that Mr. Arevalo committed this murder.
No, it's not. The defense lawyer's job is to argue that his client didn't do it.
Correct.
And he, like, this wasn't some surprise. I mean, early in the case, he said, like, listen, this was the theory, right? I guess I don't see it as a surprise, but putting aside the surprise, like, defense lawyers don't typically, like, pre-disclose to anybody what their like argument is going to look like. That's sort of the advantage you have as a defense lawyer.
I disagree on multiple levels, Your Honor. First of all, in Safiro v. United States, the United States Supreme Court said that the problem is the problem of a second prosecutor. That's why these should have been separate trials, that a defendant should not be faced with a co-defendant who essentially acts as a second prosecutor. One. Two, it was a surprise. The Tercios did not open on this. Tercios emphasizes that his theory was that Karen Figueroa was correct, that Christian Arevalo Arias had committed these crimes, but Tercios did not ask a single question of Karen Figueroa. Three, Tercios' counsel, when cross-examining the government's main witness, Guevara Rivera, cross-examined him on the theory that he had committed this murder with Abner Molina. He specifically asked him that. He never suggested that he had committed the murder with Christian Arevalo Arias. So there was an effort to hide this. But it went way beyond that, because in this particular case, what was so damaging is that Tercios' defense and Arevalo's defense had worked together to put on a case about the government's main witness, which was Guevara Rivera. And that case was, we can prove that Guevara Rivera is lying about his account of how this murder happened. And as part of that, we went in a joint presentation. I presented, as is reflected in the records, the photographic exhibits as Tercios' lawyer went through them with the investigators who helped conduct this investigation.
But the theory there is that like, no, we were really working together, and then at the end, the defense lawyer decided that his obligation to his client, and he made the best argument that he could make. I guess I'm having a hard time seeing why, like that, maybe it's an error. I'm not, like the question is not, you've set it up not as like, is this an error or not, right? Everybody sort of here assumes that there was an error. I'm not sure that's right, but let's assume it's an error. What you've said is it is such an error that we must assume that the jury ignored the instructions of the district court and like held it against your client anyway. Like that's the part that's hard, right? Like we could have I think a realistic debate about whether this was an actual error or not, and I suspect we'll have that debate with your next case. But your point is not that, like that doesn't get you there, right? Just an error. It's got to be such an error that it's like a confession, like Bruton, that you think requires.
And I believe it was, because what the jury saw was two defense teams work together, then one stand up in closing when the other was deprived of an opportunity to respond and say, hey, here's what Tercios' real story is. And at that point, implicate Arevalo Arias. Yes, we could go back and forth about this a long time, but the district court was there, and here's what the district court said. If the government had done this, it would have been clear reversible error. It would have been an absolute travesty.
Does the guilty verdict for the co-defendant, Tercios, I may be saying it wrong, does that cut against your argument that the jury, in fact, does that suggest the jury, in fact, followed the instructions?
I don't think so, Your Honor, because first of all, we don't know what the jury considered, and
Sure.
in the Eastern.
Yeah, of course, but I mean, that we have that presumption for a reason, and you're saying, hey, this is one of those cases where we can't follow the presumption. I'm suggesting, that verdict, if anything, would suggest maybe they did, and that's the only reason. Of course, we don't know what they did.
And I would look at the Supreme Court's logic in Jackson v. Deneau, where we can't parse what the jury is doing with a confession once they've heard it. It's impossible to rely on the jury to set aside the voluntariness piece, decide something is involuntary, and then just set aside the whole confession. We can't assume that the jury can ignore something this prejudicial. And I'd like to reserve the rest of my time for rebuttal, if I may.
Can I actually ask you a question
Yes,
about
Your Honor.
Mr. Vasquez's testimony? So I know that your position on the removal of Mr. Vasquez and the inability to cross-examine him, but my question is why that testimony that would have been given wouldn't just be cumulative to what is already presented, or it seems to me that there was sufficient other evidence presented at the trial, and that Mr. Vasquez's testimony would not have been so helpful as to be grounds for reversal.
I think on the issue of whether there are adequate substitutes for the testimony, what is most important about what happened here is that the FBI case agent who had interviewed Vasquez testified 3 times that he was fuzzy about his exculpatory statements. It's the only thing he was fuzzy about in this entire trial. And Detective Michelle McAllister, who is the other detective who testified about Vasquez's statements, was allowed over objection to testify that he was incredible, that she would not use his statements to support an affidavit, and that nobody had ever found him credible. So by deporting the material witness, the government was essentially able to substitute the credibility assessments of its own case agents, as opposed to Mr. Arevalo being able to present the exculpatory evidence through the witness himself.
But wasn't there other sufficient evidence to convict in the trial?
I don't think that's the question, Your Honor. The question is whether there's a plausible showing of materiality. And where the district court went wrong on this issue is, one, in holding Mr. Arevalo to a higher standard than that required by Valenzuela, Bernal, and Moussaoui, but also the court made a vital factual error in stating that Mr. Vasquez would not have testified anyway. The court said he would not cooperate, he would not testify. There's no evidence in the record to support that, and I point the court to Vasquez-Reyes' own statement in the transcripts where he told the police, the one I can testify against is Mario because he's the one who told me everything. This is a complex cast of characters in this case, but at heart there's something very simple here, which is that Mr. Arevalo's theory was that the government's 2-star witnesses, Guevara Rivera and Melina Rodriguez, committed these murders. The government deported the witness who spoke to Guevara Rivera the day after these murders, in which Guevara Rivera told him, I did this with Tecolote. It was timely, it was vital to the defense, and it went to the heart of Mr. Arevalo's theory.
Can I ask just one question before you sit down? We'll give you time when you get back up.
Thank you, Your Honor.
On the special finding question that you raise, there's a finding, under the RICO conspiracy, and then there's acquittal under the Vicar. Vicar has the purpose element that is distinct. So I guess I'm having a little hard time understanding why they're inconsistent, because a reasonable jury, and we're not looking behind them too far, but a jury could have found that all of these things happened, but it was not done for pecuniary purpose or for purpose of rising in rank, which is a sort of additional element in the Vicar context. Why are these even inconsistent at all?
Your Honor, on further reflection on this issue, I think that the key problem is really the Ramirez-Castillo problem. It's the fact that the government...
This is the yes question?
This is the special
But that's not really the argument that we made, right? The argument you made was these are inconsistent verdicts. They're not inconsistent because Vicar has a purpose element that RICO doesn't.
Your Honor, I made both arguments, and in the district court, I preserved the Ramirez-Castillo argument as part of the Rule 33 and as an alternate basis for relief under the Rule 29.
And have we ever applied what I'll call the yes rather than guilty theory to special findings? I mean, Ramirez-Castillo was a case where they used special findings instead of a guilty verdict, right? So they basically wrote out as I understood it, they sort of wrote out the elements and you answered yes to each element, but never said guilty. Here we've got a guilty, but we've got sentencing factors that require a finding by a jury. Has any court ever applied this sort of like yes theory in the context of special jury findings?
No, but I think what's important about the court's question is that the court referred to these as special sentencing factors, but under Apprendi, any fact that increases
has to be found by a jury
beyond a reasonable doubt. And the problem with the yes and no special finding as opposed to guilty or not guilty, as this court said in Ramirez-Castillo, is it creates a situation where the jury finds facts but does not then apply the burden to determine guilty or not guilty. And that's why I've come
and
to
do
believe.
you think the instructions here said that they could make those findings based on a preponderance of the evidence? I mean, the instructions seem pretty clear.
I think what's confusing is the verdict form, not the instructions, because when the jury sees over and over again, guilty, not guilty, guilty, not guilty, they know that guilt has to be proven beyond a reasonable doubt. No one has ever said to them, a finding of yes, a special finding of yes has to be proven beyond a reasonable doubt as well.
Thank you, counsel.
Thank you.
Mr. Sheriff, we're happy to hear from you.
Good morning, and may it please the court. Jacqueline Bashara for the United States. As the court understands, the parties for purposes of this appeal are in agreement that Mr. Tercios' closing argument was improper. The only point of dispute is whether the district court's corrective instruction was sufficiently curative to remedy any potential prejudice to Mr. Menjivar and Mr. Arevalo. The government's position, of course, is that this case falls within a long line of cases which apply the presumption that juries follow court's instructions. Judge Berner, I think you are absolutely correct to recognize that a key distinction between Bruton and the facts that we have here are that the arguments of counsel, no matter how improper they may or may have not have been, are simply not evidence, and the district court specifically instructed the jury that the arguments of counsel are not evidence. There was also some discussion about whether Mr. Tercios' argument was a surprise. As we'll speak more in the next case, of course, the government has agreed with the proposition that, and the district court made a finding, right, that no one before that Tercios' closing argument appreciated that he was going to point the finger at Mr. Arevalo. But in cases like—
Do you take it as actually pointing the finger at Mr. Arevalo? I mean, maybe that's the implication, but do you agree with that?
It is one implication to say, believe Karen Figueroa in saying that she was truthful when she reported back.
But he doesn't actually say it's the co-defendant that did it, right? Instead, what he says is, or she, I don't know, whoever the lawyer says,
Yes.
is like, believe this witness, not that one.
Believe that witness when she says that
X,
my co-defendant and Guevara committed the double murder, not my client. So it is, in some respects, pointing the finger. We can talk about how strong of a pointing it is. But in any event, I don't think this is like, the key case on this issue, I believe, is Wilson, where in that case, the defendant was charged with a drug conspiracy, and then for the first time in closing argument, the government argued that he was actually responsible for a murder, and that's where this court said, well, there were a number of problems in that argument, one of which was this unfair surprise, completely blindsiding the defense with a charge that they were not prepared to defend against. A key distinction here, of course, that, I mean, it was no surprise that Mr. Arevalo was on trial for murder. He was facing that charge for several years. That's what we were all at trial to argue about. And so I think that's a key distinction, and why the instruction that the district court provided here was sufficient, unlike in the Wilson case.
Can you address the deportation of witness Vasquez?
Yes, I do agree with you, Judge Berner, that Vasquez's testimony would have been cumulative to all of the other evidence that was already presented to the jury. Of course, at the outset, I would just reinforce that Vasquez had absolutely no personal knowledge of the crimes with which the defendants were actually charged, because he was not a member of MS-13. He was not present for any of these murders. All that he was a witness to were the statements that Guevara made to him. But if you read the transcript—
But the statements could have been helpful, and the defendant was not able to bring the witness. And the government knew at the time that of the deportation, that the witness had relevant evidence. And so it just strikes me that the deportation deprived the defendant of the ability to bring the witness or to cross-examine the witness. But in any event, it doesn't seem like a great rule that every time the government records a witness's testimony and already has that evidence, that it can then deport the witness and deprive the defendant from the ability to cross-examine or to put the witness on himself. And that's what your argument seems to suggest, that it was sufficient simply because it was recorded.
That's not our position. I think that goes to whether it was cumulative, and here it happens.
Right, but isn't your position that there's no error here because it was cumulative?
That's one of our arguments.
And what's the other?
Sure. Well, at the outset, we don't think that he had material favorable testimony because he was not an eyewitness to the crimes with which the defendants were charged.
Would his testimony have been admissible as substantive evidence as opposed to impeachment evidence?
I don't think so.
Right, because his testimony, it is impeachment evidence.
Sure.
Right, but under 613, it's not substantive evidence. It doesn't go to show what he heard is true or not true. And instead, it only goes to impeach what another witness might have said, and that witness was already impeached.
Yes, Your Honor.
Right? That's the theory of cumulative, that because it's not admissible as substantive evidence under the rules, that it's cumulative of the impeachment that we already have of the same witness.
Yes, and in that way, I think it is quite similar to Kaizheng Zhu, if I'm pronouncing that correctly, and that involved similar facts where the defendant was relying essentially entirely on a single sentence in an FBI report on a witness's interview to say that the witness who had been removed before trial might possibly have testified favorably for the defendant. This court recognized that that's not the standard that Valenzuela Bernal applies. It has to be more than a speculative showing that the witness would have provided some material favorable testimony, but in any event, the court recognized that the testimony would have been cumulative of testimony that was otherwise available to the defendants. And I would note, it's not just cumulative of testimony that the jury actually heard, it's just testimony that was available to the defendants. And so here, of course, the defendants, they could have asked Molina, they could have called Molina. The district court made clear that its order only applied to the government. They didn't call Molina, but in any event, the district court still permitted them to explore Vasquez's or Guevara's statements to Vasquez through numerous other avenues at this trial. I'm not sure whether the court might have any questions about the special findings. I just wanted to highlight, I think, a distinction between my friend's position and what we asserted in our brief. I think my friend is correct that in the Rule 33 motion, the defendant did make this argument about Ramirez-Castillo. The distinction I would put to the court is that the defendant, when the district court called the parties in front of it to discuss the verdict form, neither Arevalo nor Menjivar objected to the phrasing of the special findings, which is really what their argument seems to be now, especially if their argument is, well, the special verdict form itself did not require, did not, separate from the instructions, tell the jury it had to be unanimous beyond a reasonable doubt, also as to the special findings, which we know the district court did include in its instructions. If they wanted that included, I guess, 2 times on the special verdict form, it was incumbent on the defendants to ask for that relief, and they didn't do so.
I have another, are you through with your presentation?
Yes.
In kind of reading the closings related to the closing issue, this isn't really about the closing issue, but it struck me that the defense counsel in the closing that's in question describes an MS-13 expert, Guzman, that I think the government put up. Is that right?
Yes.
And describes the testimony that Guzman said that MS-13 members will lie to judges and jury. Is that really what you had an expert testify about?
On cross-examination, the expert testified that sometimes MS-13 members sort of aggrandize the crimes that they have actually committed.
But that's on cross. That's not the government.
On cross,
You
yes.
didn't
We did
ask
not elicit that testimony. And on redirect, Mr. Blanchard elicited from the expert that if leadership of a gang if it got back to the clique leadership, that someone had lied about the fact of a crime or the extent of their participation in the crime, that could trigger gang punishment such as being assaulted or even killed.
Did the government, with respect to this expert, ever ask the expert what is it a he?
Yes.
What his opinions were?
His opinions about
Usually
the gang?
experts come in to talk about opinions, and it sounds like the expert mainly talked about facts.
I understand your question. It is relatively common in these MS-13 cases to provide an expert to test about
I understand it's common. I've had this question
enterprise.
several times. I'm asking, did he give opinion testimony or did he give factual testimony?
I don't recall him rendering an opinion.
Why would you say that? He might not have used the words opinion, but when he expresses views about what MS-13 does or doesn't do, he's not talking about specific instances. He's drawing conclusions, opinions about the organization and its members, like an anthropologist might.
That's fair, Judge Richardson. The expert was not involved in the investigation of this particular case, so his testimony was not about the facts of this case. It was more broadly about his expertise, having investigated numerous MS-13 cases and interviewed.
Go ahead, finish, I'm sorry.
Just based on his experience interviewing many MS-13 members.
I think it's an interesting and fair question as to whether you have to formally say something like, do you have an opinion? You can look at a question and it may be opinion in nature or not. That's a debate, worth that we probably can't resolve here. But do you agree it's improper for the government to just call an expert witness and only provide factual testimony that's not opinion at all?
Your Honor, I think this would benefit from adversarial briefing. I'm just,
That's totally fair.
okay.
Well, one example, if you called the expert and they were testifying as an expert, and they said, and defendant one told me X, that would be inappropriate. We've said that in a
Yes,
variety of cases.
yes,
You
you
can't
have.
mix an expert's opinion testimony with factual information about the case at hand, right?
Sure.
So at least that far, you would agree.
Yes.
That type of factual information, that is case-specific factual information, needs to be at least segregated, if not done by different individuals. That part we can get to, maybe as far as Judge Quattlebaum suggests, would help to have some briefing.
Yes. I'm happy to address that in the next case where it's presented. Unless the court has any further questions, we ask that you affirm.
Thank you, counsel. Ms. Donovan, we're happy to hear from you.
Thank you, Your Honor. There are three main points I want to make in my rebuttal. The first is about the deportation of Juan Vasquez Reyes, and that is, in the district court, the United States government admitted that Vasquez Reyes was, quote, a material witness against Guevara. The United States has backed off.
Why is that? Why would his testimony be admitted as substantive evidence rather than impeachment evidence? Like what would the substantive evidence be?
We could have called him in our case to testify about the conversations that he had with Mario Guevara Rivera the day after.
On what legal theory would those conversations come in?
On the theory that Guevara.
Was it Guevara a testifying witness?
Yes, he was a testifying witness.
And so under 613, it comes in to impeach him.
Correct.
But not as substantive evidence, right? It's merely impeachment. So you can call him to impeach, right? So you would have to confront Mr. Guevara with the statement, right? Did you tell Mr. Vasquez that you killed the guy? He can confirm, deny, do whatever. If he denies it, then under 613, you can call Mr. Vasquez. But the court must instruct the jury that it is not substantive evidence. It's not evidence that Mr. Guevara did anything other than say the words, right? It's impeachment evidence only. It's not substantive evidence.
Correct, Your Honor. And let me explain why I think that's so important in this case. First of all, I did cross-examine Guevara Rivera about this conversation. He denied that it happened. He denied ever speaking to Vasquez Reyes about Melina Rodriguez, even though the evidence that he had had conversations with Vasquez Reyes the day after the murder was indisputable. So this was an important point on which a disinterested third party...
And you had evidence that you could introduce to impeach on that denial.
Yes, correct, because Vasquez Reyes said the day after the murders, Mario Guevara Rivera came to my job site with a gun and a paint can.
And the difference you're saying is that it would have been different if you had live evidence rather than non-live evidence. Like you were able to impeach that statement. You just thought you could impeach him better with live statements than with the evidence that you had.
No, I wasn't able to effectively impeach that evidence because Guevara Rivera denied making this statement. The case agent claimed that he was fuzzy on the details that he had written down in his report, specifically only the detail that Guevara Rivera had said that Tecolote was with him, that's Abner Molina, for the double murder. And the third witness, the other case agent, Michelle McAllister, testified that nobody had ever found Vasquez Reyes credible and that she did not believe he was credible over the objection that she should not be permitted to testify on the credibility of this witness. The government faults us for not calling Melina Rodriguez to testify this. Let's put that in context. Melina Rodriguez at this point has already been excluded from the trial due to Brady violations. Melina Rodriguez has given a report, a recent report, I believe November 2023, 2 months before the trial, after this evidence came out. The government went and interviewed Melina Rodriguez, and he denied ever speaking to Vasquez Reyes. Because, mind you, in one of the other police reports, it also says that Melina Rodriguez himself told Vasquez Reyes that he had committed the double murder. Melina denied ever talking to Vasquez Reyes about these crimes or ever saying that. So the idea that we could have called a hostile government cooperator whom our entire theory was the actual murderer to testify about something so exculpatory baffles me. Additionally, Melina is not some pie-in-the-sky theory. I want to highlight for the court the fact...
Wasn't there recordings of Vasquez saying this?
There was a recording of his December 13th interview, and we tried to present clips of that in the trial. The court said that the clips were, quote, miserable. Essentially, the district court held against us the lack of an adequate substitute for this testimony. The government faults the use of pronouns, the government faults the use of the interpreter who did that interview, but the fact of the matter is Vasquez Reyes spoke not fluent English, but pretty good English. He was Mirandized in English, he waived his rights in English, and then he sat there for this interview.
Just so I understand, so did you play these clips, or your argument is that you were precluded from playing any of these clips?
We played some of the clips. When we began playing the clips on the third clip, the court cut us off and said it wasn't useful and told us to be more judicious, instructed us to go and work on limiting the clips. So we were not able to make a fulsome presentation about this. And the clips were...
Right, but that's often the case, right? You get some impeachment you don't get to do, but so much of it, like that doesn't seem... Like, the court would have said the same thing if the witness was there, right? Like, you don't get to have a mini trial on impeachment. You get a limited effort to do so. It seems like to me here, you got a couple of ways of doing it. I understand they weren't perfect. Impeachment never is. That seems like the rub from my perspective.
Well, I disagree, Your Honor, and here's why. The clips weren't played in a vacuum. They had to be admitted through the detective who had given the interview, which was Detective Michelle McAllister. And she is the detective who sat there and testified and said, this was confusing, this was incredible, I would never take a statement of his and put it in an affidavit. Now, in addition to the fact that she systematically denied and dismantled his credibility, all of which were comments that did not make her police report. They were comments that came years later in trial when we were unable to produce the actual witness. This was a very problematic witness from our perspective. The government had, I encourage the court to look at her testimony in the government's case in chief, because the government had called her to testify about drug buys that she did with our client. And she had testified that her undercover persona is as a professional businesswoman, and that she had to avoid any sort of sexual implication. But then there was over 800 texts, I believe.
I understand your
It
attacks
was-
on her credibility, too. We thank you. We understand you, too, were court-appointed, and we thank you for your service, particularly in the context of what obviously was a long and difficult trial.
Thank you, Your Honor.
We'll come down and greet counsel. We'll take a brief break before we proceed to our third case of the day. go grab your colleagues? Sorry, she's going to do it. You're good. We won't start without them. All right. Mr. Lipper? Yes. Happy to hear from you.
Thank you, Judge Richardson, and may it please the court. My name is Greg Lipper. I am arguing on behalf of Carlos Tercios Villatoro. The striking after the fact of Mr. Tercios' entire closing argument was both unprecedented, foreclosed by binding precedent, and also devastating to Mr. Tercios' case. In that closing argument, Tercios' counsel offered the jury many, many reasons why the government's case against Tercios, in contrast to the case against the other two defendants, was especially weak.
Counsel, in talking about this issue with the closing, seems like one of the questions is whether the decision to strike the closing was a constitutional issue, kind of based on I forget the name of the cases, but the one that where the judge said you can give a closing, but I'm not going to listen, and the other one that said, there was a rule or something about no closings in bench trials, something to that effect. So is it a constitutional issue, or is it a sanction for an improper closing? It seems to me that's one of the things we got to answer about this. And it feels like this is more of a sanction than a categorical right from the get-go sort of thing. But I want to hear you on that.
So I think either way, it still is a constitutional issue, because the right to present a closing is so central to the defense, both under the Fifth and the Sixth Amendment.
Is it a constitutional violation if the district court struck part of it? So if you stood up and said something wildly inappropriate and the court struck a portion of the closing, it seems like you're saying that too would be a constitutional violation?
No, I'm not saying that.
So if striking in order as a sanction for misconduct doesn't violate the Sixth Amendment there, but is within the court's discretion, which obviously can still be abused, but is within the court's discretion, why are you distinguishing this, where they're, at least according to the district court, and the district court may have abused its discretion on this,
right,
but the district court found that it was rife with, a multitude of errors and misconduct, and if the district court was right about that, it seems like a sanction in the same way.
So so let me say a couple of things just so we're all, I think, operating on the same terrain. I agree with you that ultimately I think it doesn't actually matter in this case what standard you look at it under, because even if it's a discretionary decision, it was a significant abuse of discretion. And I also would say... Understand
that, but we got to answer the threshold question.
But I think it's significant in this way. I would say that let me offer this analogy. If let's say it turned out, obviously I'm so hypothetical, but let's say it turned out that trial counsel was practicing law without a license the entire trial. And at the end of the trial, trial counsel is like, it's come to my attention that trial counsel has no law license. This was obviously improper. You have to be a licensed lawyer to provide. Therefore, ladies and gentlemen of the jury, you must disregard every question that came out of defense counsel's mouth and everything in the closing. That would have been a sanction, but it would have been a sanction that operated in this case to deny Mr. Tercios or any lawyer, any defendant, his Sixth Amendment right.
So what if, on the other hand, instead of just striking one inappropriate portion, the lawyer gets up and says the prosecution's, sleeping with the judge, and, that I rest my case. And they strike it and say that's your whole closing struck because it's inappropriate. So you get nothing because everything you did was wrong.
So I take your point about that, and I think in a situation like that, though, when it's so extreme as to be justifiably, if it's so extreme that literally each and every sentence in the closing is independently strikeable, or the closing is one sentence and it's wildly inappropriate, at that point I think you have a broader question of, was defense counsel functioning properly? So ultimately the remedy there is probably going to be a mistrial for one reason or another, because one way or another defense counsel, the defendant, hasn't gotten a meaningful right to counsel. In the same,
You meaning mistrial for ineffective assistance of counsel? Like, is that the mistrial you're?
Something like that. If you have a situation where defense counsel is so obviously malfunctioning, basically, in the same way that it would if it turns out defense counsel is sleeping through 2/3 of the trial, that there would be a sanction of sorts, but ultimately you wouldn't hold that against.
So, but that's like a little odd for the court. I mean, we don't typically do ineffective assistance at that stage, and so it seems odd to me to say that a district court could find an inappropriate closing, maybe correctly, maybe incorrectly,
Right.
And that as a result, couldn't strike the closing within its discretion, not a constitutional violation. It's a sanction for misconduct.
Right.
And then we review whether was the district court correct in finding that the closing was so rife with errors that it must be struck as a whole, and that might be a abuse of discretion to do, but they were doing so under an abuse of discretion for sanction of misconduct.
Understood. I think even if you're looking at it though under an abuse of discretion standard, it's an abuse of discretion in striking the closing as opposed to abuse of discretion in limiting, some supplemental questions or a particular witness. In the same way that the district court often has discretion on the margins, even when there's cross-examination for bias, for instance. But instructing the jury to disregard an entire cross-examination for bias would likely be an abuse of discretion. But I think
Can you? I don't want to get out of order, but I guess I am going to.
Yes.
So assume just hypothetically that it was an abuse of discretion.
Yes.
Can you tell me what in that instance, we now apply harmless error and we sort of ask, I think, if the jury considered everything that was said, is there a reasonable probability that they would have done something different, right? They would have acquitted in part. With respect to the murders, I get the drug piece maybe, but with respect to the murders, tell me what was in the closing that you think would have convinced a reasonable jury? Why is it not harmless? It wasn't like a model of advocacy, and so help me understand what was in it that would have convinced a reasonable jury?
I'll be happy to do that. I think there's a number of things. Before I do that, though, I want to make 2 points, just that the government has not argued harmless error on the jury argument issue, number one.
I'm not sure that matters. I think we're under a command of the federal rules that we may not grant relief unless substantial rights are affected.
I believe that's an argument that, like many other arguments, that's an argument that the government can assert and waive. But and putting that as
I don't know about that.
all right, and the other point I would make is because again it was because the instruction implicated the constitutional right to deliver a closing, that there would still have to be, the error would have to be harmless beyond a reasonable doubt. All that said,
If it's a Sixth Amendment and not an abuse of discretion.
Well, but it can be an abuse of discretion in the same way that a limitation of the Sixth Amendment right to confront, even if there's certain aspects of that might be reviewed for abuse of discretion, it's still ultimately a constitutional error. But I would say under any standard, it was not harmless error in this case, because the case against Mr. Tercios, and this is where I want to distinguish him from the other two defendants.
Can you at least start with what, I understand you want to go to the evidence in
Yes.
general, but like, tell me, what are the 5 things that, or 2 things, or 1 thing?
Yes.
That was said in the closing that you think might have had some influence, whatever that standard we want to
Yes.
apply, on a jury? Because
Sure.
I'll just confess up front, when I read it, like, it wasn't particularly persuasive in thinking that that was going to convince a jury of anything. And so I'm just curious what you
Absolutely.
think in the closing
Yes.
itself, whether proper or improper, even if it's improper, is fine by me, but what in it that you thought was like even plausibly persuasive?
So first of all, the discussion of Karen Figueroa, who was, although it was the government's witness, Karen Figueroa, who was, I think, objectively, based on, her incentives and the reasons, her incentives to testify, was a far more credible witness than virtually all of the other co-conspirators that the government presented, testified that immediately after the shooting, Blue, the only witness against Tercios in this murder, called up her husband in the car, and on speaker, she heard Blue say that he committed this murder, it was him, and it was Arevalo, but did not mention Tercios. So right off the bat, that's a witness with no particular incentive to lie about that, number 1. Number 2, and we heard some discussion of this in the previous argument, but trial counsel also referred to 2 other witnesses who, although they weren't present, their testimony was summarized through stipulations in which, again, shortly after the murder, they heard confessions from either Molina or Blue that it was Blue and Molina who committed the murder and not Tercios. So you have 3 accounts from immediately after the murder in which Blue and or Molina are identifying themselves or Arevalo, but not Tercios.
And your argument is that without the closing argument, like the jury wouldn't have understood Blue's confession or those references, right? That evidence was sufficiently convoluted that like a jury couldn't figure out what Figueroa said?
Well,
couldn't connect the pieces? Like, what about the closing? I mean, I get this is hard, right? Because closings are not evidence, right? And so, but the evidence on that point seems to be pretty straightforward. The argument seemed not to be straightforward. Maybe it's as the evidence was. Help me understand why you think the argument. I get the evidence point.
I actually think the argument was straightforward in the sense of, I think Figueroa was one of the more recent, Figueroa, I think, was presenting of like, this is a witness with far less reason to lie than the other people, and she is inculpating these 2 and not inculpating my client. But this is where I think you can't separate the harm from the error from the importance of the closing argument. The reason why in Herring and then in this court's case, the 1981 case, I believe it's King, the reason there is such a strong right to a closing is because it is the only opportunity for defense counsel to synthesize everything that's happened. And here, as even the district court recognized, this was a long trial, it was a complicated trial, there were a lot of different names, there were a lot of different people, there were a lot of different nicknames and alter egos. Even as we heard in the prior argument, Tercios's counsel wasn't even the one, because the responsibilities per the district court's order were divided up amongst defense counsel. The jury hadn't even heard Tercios's counsel confront Figueroa directly, if I'm correct about that, because of the division of responsibility. So this was, especially in a complicated co-defendant trial, this was absolutely the only opportunity for Tercios to have everything synthesized into a whole. And to emphasize, here are the witnesses and here are the facts that are important to Tercios, as opposed, because, and again, I think this is important, a lot of those other witnesses, they didn't exculpate, Karen Figueroa didn't exculpate Arevalo, so Arevalo's counsel had no incentive to emphasize this. Tercios's counsel did. The other thing I want to mention is the alibi witness that was unique to Tercios, because the government's theory was this was the murder happened in a continuous course of action, starting the night of the 21st and going into the morning, early in the morning of the 22nd. And in fact, Blue, again, the sole eyewitness against Tercios, testified that they were together from the night before into the morning, that they were driving around looking for one of the people, and eventually they found him and then they killed it. So a continuous multi-hour course of events starting the night before and continuing. And the alibi witness, and who testified actually a very specific reason why she remembered it was that night that she had seen him, testified that she was with Mr. Tercios in his, say, residence, in his tent, from 11 p.m. until 12 a.m. on the night of the 21st, which means that Blue's testimony that all three of them were in the car together starting the night before continuously it would not have been, if the alibi witness...
Can you address the point that an alibi is not an impeachment of a witness, but is instead that you were not present for the crime? Right, so we don't give an alibi instruction anytime you have another witness who testifies to something that impeaches the testimony, right?
Understood.
Right? Because I take your point to be,
Right.
Blue couldn't have been fully truthful when he says he was with them all night into the next morning, because at midnight he was somewhere else. That's not really an alibi unless the murder happened between 11 and midnight, right? It's an alibi. It's a impeachment perhaps of Blue, but it's not an alibi. An alibi is that you were not present at the time of the crime, and the crime here is at an unknown time.
I see my time has expired. May I answer?
You can definitely answer.
Thank you. So I think that the distinction you identified, I think, in the context of prejudice to Tercios does not...
It's not prejudice, it's just whether there's an error in giving the alibi instruction at all.
Well, so, but I was actually pointing to the alibi in the context of further prejudice from the striking of the closing, because the alibi witness was discussed in the closing. And
Okay.
I think you have to look at the alibi, and there's a case, I believe from the Eighth Circuit we cited, that raised a similar point. When the only testimony about Tercios' involvement, when the theory of the case in practice as presented was all of these people were together from time A until time B continuously, and then you have a witness that says, well, he wasn't there during part of that continuous block. Yes, in theory, there could have, perhaps a sufficiency challenge, there might have been sufficient evidence for a jury to conclude, but in terms of actual effect on the deliberations or effect on the application of the reasonable doubt standard, if the only witness putting Tercios in the crime is saying, he was in the car with me from 11 p.m. until 2, 3 a.m., and now you have a witness saying, well, no, he wasn't, then if believed, it undermines the only explanation for how Tercios participated in this murder, and thus, whether or not it would require a directed verdict, it certainly would inform the deliberations of the jury when they're considering whether it had been proven beyond a reasonable doubt.
Thank you, counsel.
Thank you.
Hear from you again in a minute.
Thank you.
Happy to hear from you.
May it please the court. The Constitution, of course, protects a defendant's right to an opportunity to present a closing argument. The Constitution does not protect a defendant's right to deliver an improper closing argument. That's the fundamental distinction that my colleague and I are drawing in this case.
But you're not arguing that the entire closing was improper, are you?
That was the district court's finding.
Well, the district court struck the entire closing. I don't
Yes.
think that's the same as finding that the entire closing was improper.
The district court found it was, quote, an inappropriate closing argument almost from the beginning. That's at JA 3697. In denying the post-trial motions, she found it was way beyond the bounds of an appropriate closing argument. That's at JA 4111. She went on to say, I've just never seen it done like that before, and this is a judge who's been practicing.
What's wrong with what the closing said about the, call it alibi, with the caveat that Judge Richardson just mentioned? I mean, the closing, they talked about this witness who came and said, you know, from this time period, I was with Tercios. I mean, there was no, that wasn't anything that anyone objected to as being improper. That wasn't anything that was used to describe improprieties in the closing. And yet, she said, you must disregard counsel's pointing out that fact.
So perhaps that sentence or paragraph as to the alibi argument?
No, this is actually the one place where I think the closing argument was wrong, right? As opposed to, like, tons of places I think weren't. But the argument assumed facts not in evidence, that the murder happened between 11 and 12.
Yes,
right?
Your Honor.
The argument did not make the argument that we heard, which is a very plausible argument from your colleague, that this showed that Blue was a liar because he said he was there the whole time. The argument, as I understood it, was that this was an actual alibi, that he wasn't there with the murder, because we can understand, based on some facts that don't really exist, that we can presume the murder happened between 11 and 12. Right, so this was assuming, the whole premise of the argument here was to assume facts not in evidence. That is, the murder happened between 11 and 12, right?
That's fair, Your Honor, and that was one of several instances of counsel arguing facts that were not in evidence, and I think that's one of the overarching problems with the closing argument.
But what about the notion that, if you, and I'm not blaming the government from this, because it sounded like there were efforts to object that may have not been, permitted. But typically, if there's an improper statement in a closing argument, there's an objection. And if the court sustains the objection, everyone knows that, A, it's struck at that time, and B, the defense lawyer at least has the ability to, or whatever lawyer, has the ability to then react and, give his or her best effort at a proper one. That seems like that's, a problem here, doing this after the fact rather than as the issues came up, kept the defendant here from being able to adjust and do anything.
So if I could address that in two parts. First, as far as whether there was an objection, yes, at JA 3669, Mr. Blanchard said objection. It's in the transcript, and
the district court said, no,
don't object.
you can't do it.
Is
Yeah.
what the district court said.
And then the district court later, after the fact, said he tried to object and I kind of waved him down. So
Yes, once or twice.
Yeah, my point is not that the government wasn't trying to object. It's
Okay.
not really a preservation issue, is that it was an error, or why was that not an error?
I understand your question to be directed at the district court choosing to resolve this issue at the end of the closing rather than during. And a couple of observations. I think certainly the district court could have either permitted contemporaneous objections, or the district court could have intervened sua sponte. However, that carried...
Wait, I'm sorry. You said the district court could have permitted contemporaneous interjections or objections. That seems to suggest that you think it's a permissible rule for a district court to prohibit contemporaneous objections? That seems like a wild rule. I mean, if maybe that particular rule, apparently, local rule of this judge is maybe not challenged here, but that would be a wild rule that you are prohibited from objecting, either side.
Yes, Your Honor. I'm not sure it's a rule. It's more of a policy. I would note this court actually upheld this practice of Judge Brinkema's in a case called Wills from 2003, where defense counsel tried to object during the government's closing argument, and Judge Brinkema in that case said, don't object, wait until your turn, and then you can address the improper remarks in your closing.
Is that a published opinion?
Yes, I'm just looking for the citation, and I would be happy to provide it for you. Wills, this is 346 F. 3rd 476, Fourth Circuit, 2003.
Okay.
It is in the briefs. I can't recall exactly where, but it is cited here.
That's helpful.
Returning to why it was not an abuse of discretion to wait until the end of the closings to address the improper remarks, it could have been more damaging to counsel and/or to the jury's sort of reception of the closing arguments to have the district court interject in the presence of the jury and comment on defense counsel's perhaps improper presentation to the jury. It also could have drawn more attention to these remarks in the moment.
That would have been more prejudicial than striking the entire closing and instructing the jury to disregard it?
I'm thinking about, there's a case, it's cited at page 6 of the reply brief. It's just a string cite, but it's an interesting set of facts. It's called Busick from the Second Circuit. In that case, it was a significantly longer closing argument, approximately 3 hours after a 5-week trial. And in that case, the district court interrupted defense counsel 44 times. Now, a majority of that panel said that was not an abuse of discretion on the facts of that case, but acknowledged that on a different set of facts, to have the district court continually interjecting and essentially reprimanding defense counsel about why their remarks were improper could deprive the defendant of a fair trial. That's what I'm getting at. I understand this is a different set of facts.
But counsel, listen to this part. It's not just to disregard the closing. That's a lot, because that at least, gets back to Judge Richardson's point that there was evidence presented and the jury might have remembered it, and despite the arguments that might have been hard given the length and number of players here, but putting all that aside, right after saying that says, you may not use any of the information or argument she offered as you deliberate in this case. I mean, what do you do with that? You can't use any of the information.
Yes.
That doesn't say go back and disregard the evidence that came in, but, maybe they might have thought that.
My understanding of that instruction was that the district court was instructing the jury not to consider in its deliberations the information that was not in evidence. And that's a perfectly proper instruction. I mean, that's the entire reason why there are rules about
But that's not
proper closing.
You may not use any of the information or arguments she offered as you deliberate in this case. I mean, there was stuff not in evidence talked about, but there was stuff that was in evidence talked about. And doesn't that instruction say you can't consider the evidence she talked about that was in the case as you deliberate?
It can be read that way. I was focusing on the information or arguments because I think the overarching concern is about having the jury reach a verdict based on something other than the evidence presented in the case, which is really, that goes to the heart of the district court's responsibility to control what goes to the fact finder. And that's why I think she was correct to be most concerned about the vouching for Karen Figueroa and the arguing of multiple facts that were simply not in evidence here.
But rather than instructing the jury to disregard those specific segments of the closing, as Judge Quattlebaum points out, the instruction was to disregard the entire closing, both the arguments and the information.
That's correct, Your Honor. Again, I think we could be here in a different posture if the district court had sort of cataloged, here are 15 or 20 different remarks that were improper, and here are the reasons why. That would not only highlight for the jury, sort of drawing new emphasis to the improper remarks, and also possibly cast defense counsel in an improper or negative light by highlighting just the volume of improper remarks here.
I mean, just as a practical matter.
Yes.
You've heard a few closing arguments before, and I venture to say that, like, improperly, admittedly, but virtually all of them include some version of vouching, even if just accidentally, I believe. I mean, you could say anything, if you put I believe in front of it, it's improper vouching. If we had a rule that, like, vouching and referencing quote-unquote facts not in evidence, when, lawyers on both sides tell stories to illustrate points, if we could strike the whole closing anytime that happens, that's like a pretty remarkable, like, set of circumstances, particularly where the defense lawyer doesn't know that they've exceeded what that judge finds to be appropriate until after the case is closed. I mean, that's like a remarkable line for the government to suggest.
I don't think it's that remarkable, just because these are foundational concepts that lawyers learn, both prosecutors and defense attorneys understand It's a cardinal rule that you can't argue
Have
facts
you-
not in evidence.
Have you argued harmless error, and do you think it matters that you have not? To presuppose the answer to the first question.
I mean, I will just acknowledge the brief does not assert a separate harmlessness ground. I think you're correct that the court could resolve the case on that basis if
What's
in the exercise of
assume
your
we can
discretion.
assume we can consider it. Give me your harmless error argument.
I think the best evidence of that is the fact that Arevalo and Menjivar, whose closing arguments the jury was permitted to consider, were convicted of all the same counts that Mr. Tercios was.
Are you aware of any cases where the district court has struck an entire argument?
No, Your Honor.
Do you have anything else?
Unless the court has any further questions, we ask that you affirm.
Thank you, counsel. Mr. Lieber, you've got a few minutes.
Thank you, Judge Richardson. One thing I just want to clarify up front. I think, first of all, it's implausible to say that striking the closing in full is somehow a less restrictive option than striking certain portions of it during the closing. But to the extent the government's suggesting that the trial court did this to protect the credibility of defense counsel, when the trial court instructed the jury to disregard the closing in full, she also several times said that trial counsel had acted improperly, had engaged in, I forget if she said the word misconduct, but she said something to that effect several times. So we got the double whammy here of not only was the argument struck in full, but also trial counsel's credibility was attacked several times. And as Judge Quattlebaum pointed out, that the jury was instructed to disregard the information contained there, and I want to just emphasize the government's concession that the instruction can be read the way I think Judge Quattlebaum posited and the way we posited. Point number one. Point number two, the fact that the other two co-defendants were also convicted, notwithstanding the fact that they were allowed to deliver closings, does not allow the court to say, well, obviously closings wouldn't have mattered for anyone in this case, including Tercios, because the evidence against those other two defendants was much stronger. I mean, Arevalo, unlike Mr. Tercios, Arevalo had been corresponding by text with one of the victims, and Arevalo essentially endorsed a memo that Blue had prepared saying that he had participated, whereas Tercios didn't. So you had essentially an adopted admission by Arevalo, whereas the evidence against Tercios was Blue and Blue alone, and where you had multiple witnesses, including Figueroa, saying that other people were involved and not Tercios. And so you can't simply say, well, the other two defendants had closings and were convicted, therefore a closing could have not possibly have mattered to Tercios. Judge Richardson, I wanted to address one point I think you had alluded to in questioning the government about the closing arguments discussion of the alibi, because I actually don't think it was quite, or it may have been Judge Quattlebaum, I apologize, I forget which one, but I don't think the closing was.
So you can't tell the difference between us?
I take that as a compliment, by the way, in case there's ambiguity.
Your Honor, it's very hard to tell judicial robes apart.
Totally teasing.
Especially when there's no stripes. What trial counsel said, and so on JA 36, pardon me, I just lost my place. What trial counsel said, first she was discussing the testimony about what was going on the night before, the driving around, and then I believe it is 36, it's in the 3660 area. I apologize, I had it in front of me and then turned the page. But what trial counsel said was, the witness, the alibi witness, said she was with Tercios from 11 p.m. until 12 a.m. And again, it doesn't, whether or not it made it formally impossible for Tercios to have participated in the shooting, it certainly made it impossible for the shooting to have taken place the way the sole witness against him described it. And again, it's the government's burden to prove beyond a reasonable doubt that Tercios committed the crime. And so if the government is presenting a single explanation for how Tercios participated in the crime, and then a defense witness is saying, well, no, he was with me for part of the time, he was in his own house, or in his own tent, not in this other guy's car, that certainly could have affected the outcome given the government's burden of proof. I'm sorry, was there
that's fine. I understand your point.
And actually, it's the JA3664 is where the discussion is. So it's the middle paragraph where first the trial counsel just points out that the witness has no incentive to lie, and then she came in, she told you that she hiked up the hill behind the trailer park and she was with him from 11 p.m. to 12 a.m. that night. And that is, the final point I want to make is not only are the things that the government now claims as misconduct, things that the case law generally permits lawyers to do or understands happen sometimes, but it would be quite anomalous for this to be both the only case in which a closing the jury has been told to disregard a closing in full on the one hand, and yet to have not only this few objections, but also the trial court, who was not shy about interrupting closings. I mean, Tercios' counsel got interrupted at least once because she strayed from the lectern a few too many paces when using the Elmo. Trial counsel was not shy about interrupting closings, and yet this closing that supposedly was tainted from the start drew no comment in its substance or style from the trial court throughout. And it seems like those two sets of circumstances are very difficult to reconcile. Unless the court has any further questions?
Thank you, Mr. Lipper. As court-appointed counsel, we appreciate your hard work on this appeal, and to the extent you're involved below in your work there, too.
Thank you, Your Honor.
Thank you, counsel. We'll come down and greet counsel, and we'll proceed to our fourth and final case. We're not in a rush, even though it's Friday, but we'll go to our next case as soon as counsel is ready, 24-4197. Give us just a moment, let counsel get situated, and we'll be happy to hear from you, Mr. Rossi.
Rossi.
Mr. Rossi.
Thank you, Your Honor.
You
May I
ready?
proceed?
Please.
Counsel. May it please the court, I'm Gene Rossi, and my colleague Jillian Blumenthal. We represent Dr. Kirsten Ball, who is a defendant appellant in this case. Your Honors, this matter involves a flawed analysis of what the Supreme Court said in Ruan and also in Smithers. Both cases cited, directly and indirectly, a famous criminal tax case called United States versus Cheek. And the reason I mention Cheek is it sets forth a subjective good faith test for a pain management physician in the issuance of a prescription. And I will get to more details on why Cheek is so important to this case, because Justice Breyer, and to some extent the concurrence by Justice Alito, adopted wholly the logic of Cheek in applying the mens rea scienter to a physician who's trying to seek authorization under Title 21, Section 841A. The court's jury instructions are at the heart of our appeal. And our position is this, Your Honors: they were wholly inadequate in conveying to the jury the argument that I could have made before the jury. And I want to punctuate that point. I've listened to the 3 cases before this, and I think it's fair to say that when the district court judge says you can't make an argument in closing, you can take that to the bank. And the district court judge, in good faith, no pun intended, has a reading or had a reading of Ruan and Smithers and Cheek that is legal error, and it was harmful to our case. What happened in this case is the government and the defense filed a set of proposed jury instructions, joint, agreed, several days before trial. We worked very hard on that, as the evidence in the record suggests. And we filed that with the court. And words are important, especially in the law. And in our joint agreed proposed jury instructions, the word HER is predominant. Predominant. And the reason it was emphasized in our view is that word her, in the usual course of her professional practice. The reason that word HER is so important is that it takes away from the jury the role of comparing a doctor's subjective belief to some reasonable avatar of a medical doctor. And I'm going to get to that in a moment. But here is what happened.
But counsel, is
Yes, sir.
Just because I've read the briefs and I think I understand where you're coming from.
Yes.
I mean, you're 100% right that the mens rea requires a subjective intent, and but the subjective intent is that the prescription of the drugs are outside the bounds of a normal, ordinary practice, of the ordinary practice. And why isn't it okay if the court has emphasized that you must have a subjective intent for there to be implicit in there is an objective standard, and whether the particular practice is consistent with that or not is relevant to whether the defendant has a subjective intent. Not determining, it's not like you're outside it, therefore you're liable like a med-mal case, but you know you're outside it and how far your practice deviates from that objective standard matters.
Judge Quattlebaum, you asked the question that goes to the heart of our case. And the answer is in the opinion in Ruan, pages 13, 14, and 15, in the majority opinion. And I'll get to Justice Alito in its concurrence. On pages 13, 14, and 15, Your Honor will find the answer to that question. The United States Solicitor General made the same argument that for that authorized clause of Section 841, made the same argument that you cannot allow idiosyncrasies. You can't allow wildly idiosyncratic conduct that's outside of what an objective, reasonable doctor would be. Justice Breyer, Your Honor, with utmost respect, he rejected that argument. He rejected it. And it's on the last paragraph of page 13. He rejected it.
So I understand your...
Yes, sir.
What the opinion says is that you have to have subjective intent, and when the government says, well, that would mean someone could have some kind of way out there sort of view,
Yep.
They'd say, yeah, if it was subjectively their belief, that's enough. But then the opinion goes on to say that the regulation defining the scope of the doctor's prescribing authority does so by reference to objective criteria, such as legitimate medical purpose and usual course of professional practice. And then it goes on after the cite to say, as we have said before, the more unreasonable a defendant's asserted beliefs and misunderstandings are, and here's what I'm getting to, especially as measured against objective criteria, the more likely the jury may find that the government has carried its burden.
Here's our response to that, Your Honor. It's an excellent question. And it goes to Cheek. And the reason I mention Cheek so much, so far, so quickly, is the court is adopting the test in Cheek. And it's a Title 26 case, income tax case, involving a airline pilot. In Cheek, the court said an individual or even a tax preparer can have irrational beliefs, can have incredible beliefs, can have gross misunderstandings, can have unreasonable beliefs. But the test in Cheek, which was applied in Ruan, is that you have to compare their conduct and how they acted, and you can compare it to objective standards. Our point is this: by taking out that pronoun, HER, Your Honor, and this is in our brief, especially the reply, Your Honor, by taking out that HER, it told the jury that they have to compare her conduct, Dr. Ball's conduct, to an objective standard. And Ruan rejects that. In the same pages that Your Honor just quoted, there's talk, I think it's the next page, where they reject this reasonable doctor test. You can't tie, this is the point, you cannot tie, Your Honor, a doctor's conduct to a reasonable doctor. And Justice Alito talks about this in the concurrence. He says you can be a reckless doctor, you can be a bad doctor, but we cannot say that just because you're a bad doctor, when compared to an objective standard, you're guilty. That's an important point that Justice Alito makes, and it's probably the most profound part of that opinion. And it goes back to, does that doctor, Dr. Ball, have a subjective good faith belief that when she issued that prescription in the course of her medical practice, was she trying to achieve a medical purpose? And the jury was not allowed to consider that. And with the utmost respect to the trial judge, I was informed that I could not make any wildly idiosyncratic arguments that say that she went a little bit too far on prescriptions when compared to an objective standard. I can't argue that that's allowed. Well, here's the problem with the evidence in this case, in our favor, I should say. The CDC guidelines in 2016 and then in 2022 were changed. And it was dramatically changed. And we brought that up at trial, Your Honor. And the CDC guidelines in 2022 said that the guidelines are voluntary, they're recommendations. And the reason we're making it this way, in my view, is we want doctors to be able to focus on the particular, I can't pronounce it, on the particular needs of the patient. And that gets to her professional practice. And the judge below gave a tell. And for the record, I want to refer to 3 parts in the joint appendix that just lay out what happened here. Joint Appendix 1903 is when Judge Brinkman in the charging conference made the comment that Ruan prohibits idiosyncratic arguments. And in that pretrial conference, after she rejected the joint agreed proposed instructions, she said, I'm going to change the CFR. She changed the CFR. The second important part of this case is, with utmost respect to my colleague on the other side, she followed the lead of the judge, and the prosecutor made a comment that you can't have wildly idiosyncratic practices. They are tied, T-I-E-D, to objective standards. That comment...
So can I go?
Yes, sir.
Just on our decision in NALM, which is the 2025 decision, we say that Ruan holds that a physician must have subjectively believed that
Yep.
his conduct was outside the bounds of professional practice, right? Not that physician's personal practice, but professional practice. Why doesn't that case, maybe you think the case is wrong, but why doesn't that case resolve? I happen to think it's consistent with Ruan, but even if you think that case is wrong, why doesn't that resolve this question? Because in essence, what Judge Brinkema did, maybe it was before NOM came out, but applied that standard, which is subjective belief that it was outside the bounds of these not there, but I read that to say the professional practice, not outside the bounds of her idiosyncratic practice.
Your Honor.
Because if she was running let's say she's just a straight drug dealer, right? But, you know, if that's what her practice was, well, it would be within the bounds of her drug dealing practice to deal drugs. And it seems like Ruan's not saying that, and NOM's not saying that it's asking the question, do you subjectively believe that it's within the objective bounds of professional practice?
Your Honor, I respectfully disagree.
I don't have any doubt about that. Tell me why. I know that you don't disagree, but why?
Your
Tell
Honor,
me why I should ignore the language from the panel decision, interpreting Ruan, it seems to me, the way Judge Brinkema did, and not the way you want us to by looking back at Cheek or some other.
that opinion does not say that usual course of professional practice, that opinion does not say that the subjective good faith is tied to objective standards. It doesn't say that, Your Honor. What it says is...
So when we read
Yes.
outside the bounds of professional practice,
You
you think I should read professional practice there to be what? Other than objective?
of the doctor's professional practice, and then we go back to Cheek. Your Honor?
No,
Yeah.
that's like flatly not what the case says, right? I mean, I understand that you
Yeah.
have this argument that Ruan said something other than what Judge Brinkema determined. But maybe I've got the quote wrong, right? I'm at 239, subjectively believed his conduct was outside the bounds of professional practice. Not his or hers or this particular, but professional practice, which is an objective standard, no?
Your Honor, I am on page 13 of Ruan. And
I'm not asking about Ruan, right? Because we're bound by panel precedent. And if panel precedent directs that Ruan means the following, right? That is an objective standard for professional practice, then we're bound by it, right? It's like a full stop, right? And so I guess I understand that you have an argument that we ought to read Ruan in light of Cheek, and if we pull these words out, we can tell this story. I totally get it. Like, I understand it. I'm not saying it's persuasive. I'm just saying I understand your argument.
Sure, Your Honor.
But the question I'm asking is like a narrower one, which is, I am absolutely bound by a prior panel. If I think it is crazy, I'm still bound by it. And so what I'm asking is, what do I do with the language of NOM that describes Ruan's holding in a manner that, to me at least, says the bounds of professional practice, which is an objective question? A subjective belief that you fall within the objective bounds of professional practice.
Your Honor, it goes back to the court eliminated and prevented and deprived us of making an idiosyncratic argument about the practicing methods of Dr. Ball.
Totally understand that, but did you make that argument on appeal? Right?
Yeah, yes, we did, absolutely.
As a distinct argument from the jury instructions?
Yeah, absolutely, Your Honor, yes. Yes, and what we did further, in our reply especially, we focused on how the removal of that pronoun, HER, made the test.
I'm working under an assumption now, just for hypothetically.
Your Honor, my time is up.
I think my colleagues will let you answer. I'm working on it, just accept hypothetically that
Sure.
the instruction is correct. Tell me what your argument I'll go look at it. What is the argument that you're making if I assume the instruction was exactly correct? It is legally perfect.
The goal and the mode of the instruction was to prohibit me from making an argument.
No, but what I'm asking is, if hypothetically, just
Yes.
help me walk through, right?
Yes,
I
Your
understand
Honor.
you disagree with the hypothetical, right? But if hypothetically I found that the instruction was literally perfect, do you have a different argument that you've raised on appeal that I need to address? That's what I'm asking.
No, Your Honor.
Okay, all right, I just want to
Yeah.
make sure. All right,
I did want to add one more point. and
You may,
I-
please.
In Ruan, it says, "The government's standard would turn a defendant's criminal liability on the mental state of a hypothetical reasonable doctor, not on the mental state of the defendant himself or herself." That states to me, when they cite Cheek, that they're not comparing it per se and tying it to an objective standard. Thank you, Your Honor.
I understand the argument.
Thank you, Your Honor. Thank you.
Ms. Rumbaugh? Rumbaugh. We'll be happy to hear from you.
May it please the court, counsel, Catherine Rumbaugh for the United States. I want to start by giving a brief summary of the evidence that showed the defendant's subjective knowledge in this case. This case was about a doctor who, when her pain patients submitted urine tests that were positive for heroin metabolites, she documented that they had consumed poppy seeds in a variety of formats. When a patient displayed visible track marks indicative of intravenous drug use, when a patient admitted to Dr. Ball that the patient had used heroin, she continued to prescribe large amounts of oxycodone. She falsified records that she submitted to the Board of Medicine. She withheld damaging records from the Board of Medicine. She had her untrained assistant documenting fake patient notes under a fake name to cover for the assistant's and the assistant's family members' own oxycodone prescriptions. When patients admitted to the doctor that they had overtaken their oxycodone pills or shared their pills with family members, she simply ignored it or told them not to tell me, don't tell me that, and continued prescribing. And all of this happened after she signed a consent order with the Board of Medicine admitting that she'd violated the standards of care for prescribing opioids. She made her patients sign a pain contract setting forth certain policies that she never enforced. She left written prescriptions for large amounts of oxycodone on her door for patients who traveled as far away as 7 hours to come pick up without having to see her for an in-person appointment or an examination.
So, counsel, I don't mean to interrupt you on the facts, but you're talking about evidence, it sounds like, that was used to show that her practice was outside the bounds of ordinary practice, and the extent of it is evidenced as that she subjectively knew it was outside those bounds.
Yes, Your Honor, that's exactly correct.
So I don't really hear the defendant arguing there wasn't evidence of that. What I hear the defendant arguing is, hey, that's the wrong question. The question is only whether it was outside the bounds of her normal practice. Did she believe that? What's your position on that?
Your Honor, it's the government's position that the defendant seeks to collapse the distinction between the objective authorization element and the subjective mens rea element. And so I want to start, starting with the statute itself. 841 makes it a federal crime except as authorized for any person knowingly or intentionally to manufacture, et cetera, a controlled substance, in this case, oxycodone. And a prescription is only authorized under 21 CFR 1306.04A when a doctor issues it, quote, for a legitimate medical purpose acting in the usual course of his, or in this case her, professional practice.
What do you do with that? What do you do? Let's let's put Ruan,
Yes, sir.
aside from for just, right now. What do you do with his in the regulation? What does that suggest? How do you read that?
Well, Your Honor, I would refer you to what the district court said at sentencing in this case, which was, quote, and this is from JA 2201, just so we're clear, grammatically speaking, her practice does not mean her idiosyncratic personal practice. Her practice is the medical field she's in. So if a doctor is an ophthalmologist, the doctor's practice is the practice of ophthalmology.
So in other words, if you were talking about outside the bounds of your practice, it would mean outside the bounds of the law.
Maybe federal prosecutor.
Yeah, maybe, yeah.
That's right, exactly. So the field that, for example, I am in is the field of a federal criminal prosecutor. And if I knowingly act, I'm now getting my metaphor a little bit far afield.
Yeah.
But
He made you do it. It's not your fault.
I think perhaps a more apt way to think about it is if you take the defendant's argument to its logical conclusion, and I think Judge Richardson, you may have been getting at this. Imagine a psychiatrist, for example, who, while fully aware of the prevailing standards of psychiatric care, believes that the best way to achieve a psychological breakthrough with his or her patients is to pump up opioid-naive patients so full of oxycodone that they become catatonic. That person could never be prosecuted for drug distribution so long as they treated all of their patients consistently.
But you agree, don't you, that this is not a negligence standard?
I do, Your Honor, I do agree with that.
And what did the district court do to ensure this wasn't a prosecution, a criminal conviction for medical malpractice?
So, Your Honor, that was included in the jury instructions. This is in JA 1659 to 1660. The exact jury instruction was, in civil medical malpractice cases, the standard is negligence. That is whether the doctor negligently departed from prevailing standards of care governing the doctor's field of specialty. A criminal prosecution requires more. That is, proof beyond a reasonable doubt that the doctor knowingly or intentionally acted outside the bounds of professional medical practice, as his or her authority was being used not for treatment of a patient, but for something other than a legitimate medical purpose, such as the personal profit of the physician or assisting another in the maintenance of a drug habit. So it's the government's position that that very clearly, without question, distinguished the criminal mens rea that the jury was required to find in this case from a civil medical malpractice case. Now, my friend, Mr. Rossi, relies heavily on Cheek, and I did want to address that briefly. Cheek addressed a willfulness standard, which is not the standard in Title 20, in 841 cases. We're looking at a question of knowledge. And more importantly, the government did cite to Cheek in its response brief in the context of Ruan, because that is the context in which the Supreme Court addressed the application of Cheek in prosecuting medical prescribers under Title 21. Namely, and I think Mr. Rossi addressed this, in Ruan the government had argued that if the Supreme Court decided Ruan against it, it would be required to prove, it would allow, quote, bad apple doctors to escape liability by claiming idiosyncratic views about their prescribing authority. The Supreme Court, as we know, rejected the government's concern in that case because, citing Cheek, it said that you can prove knowledge by circumstantial evidence. The more unreasonable a defendant's asserted beliefs or misunderstandings are, measured against objective criteria, the more likely the jury will find that the government has carried its burden. And, based on the evidence that the government presented at trial, some of which I reviewed at the beginning of my presentation, that's exactly what happened here.
That language about the whole, from Ruan you just talked about before, the part that refers to the objective criteria, is to answer the question about whether knowledge applies to authorization, correct?
I'm sorry, Your Honor, could you ask the question again?
The language in Ruan that says, the government I'll just read it. Finally, the government argues that requiring it to prove a doctor knowingly or intentionally acted not as authorized, that was the question, whether the knowledge requirement was applying to the authorization or not.
Yes, Your Honor, that's exactly right. In Ruan, the question was, do you have to does the government have to prove beyond a reasonable doubt that the physician subjectively knew that she was acting in an unauthorized manner, meaning knew that she was acting contrary to objective standards of care?
Okay.
Let's see. The defendant also asserts in its reply that the government doesn't address the case of Dul-Delau, which is an 11th Circuit case. The government did address Dul-Delau in its post-trial briefing. That's at JA 2043 to 44. And that case is simply inapposite here. In Dul-Delau, the district court erroneously, told the jury that, quote, whether the defendant acted outside the usual course of practice is to be judged objectively by reference to standards of medical practice, and that the jury, quote, must not consider what the defendant believed to be proper medical practice. These statements are obviously wrong under Ruan, and that's completely different from what the trial court said here. Now, Mr. Rossi made a good deal of hay about the fact that, about his position that the instructions prevented him from making his argument to the jury in closing. And I think that that's simply not correct. If you go to JA 1615, this is the part of the transcript where the defendant made his closing argument. The argument that was presented to the jury was, this is not a civil case, it's not medical malpractice, it's not negligence, you're taking it to another level, let's take it up a notch, like Emerald the chef would say. Good faith is a tough burden because it means the defendant acted in accordance with what she subjectively believed. And you might think her subjective belief is unreasonable, but it's what she believed. She believed the best in people. That was her Achilles heel. She loved people. That was her Achilles heel. Skipping down a few lines, she subjectively believed she was doing the right thing. At the end of the day, the overriding theme is that she was played. She was played like a fiddle. Every witness said that. She was compassionate. She was trusting. She believed me. That's not a criminal. And so the very argument that the defendant asserts that she was not able to make because of the instructions, she did actually make. So the jury was able to consider it and rejected it.
And so if the evidence had shown, you think a jury could have found, maybe not on the evidence here, but a jury could have found that she subjectively but unreasonably believed that she was prescribing these drugs for a legitimate medical purpose. And if they found that, she was not guilty.
Your Honor, I think that the jury could consider, based on the good faith instruction that the judge provided and the argument of counsel, I think the jury could have considered whether she subjectively believed that she was acting in accordance with the bounds of medical practice.
That's what a legitimate medical purpose is, right?
Yes.
I wasn't trying to, it wasn't meant to be a trick question, right? Like, if she's doing it for a legitimate medical purpose, even if she happens to be wrong about it, that would be, is your view that would be sufficient for a not guilty verdict or not?
So the way that the regulation is written is to be authorized, the prescription must be made for a legitimate medical purpose in the usual course of professional practice. So essentially, there's a requirement of both. If you flip it around and frame it negatively, then the instruction would say that the government must prove that the defendant knowingly and intentionally issued a prescription not for a legitimate medical purpose or outside, knowingly and intentionally outside the usual course of professional practice.
So your point is that alone, so the subjective belief that it was for a legitimate purpose would not suffice for a not guilty verdict. You would also have to find, as a jury, that it was within the sort of standards of medical practice.
You would have
So long
to-
as there was a subjective belief of that. It doesn't matter whether it was actually within the bounds of medical practice. If she subjectively believed it was, even incorrectly, in both instances, if both of these beliefs were incorrect, but subjectively true, that's what is required to get a not guilty verdict. I know I'm flipping the burden.
Yes, Your Honor, yes, sir.
Well, it does matter if it's outside, doesn't it? It's double. It must be both outside and she must know it. Is that right?
Your Honor, for a prescription to be authorized, both must be issued for a legitimate medical purpose and in the usual course of professional
Right.
practice.
And she must know that it's not in both instances.
I'm going to try not to flip around my
yeah.
negatives and say anything incorrectly, but essentially, I think I agree with you.
Okay.
Finally, as the government's position is obviously that the jury instructions correctly stated the standard as set forth in Ruan and in the precedent before this court, but to the extent that there's any error, it was clearly harmless in light of all of the evidence that the government presented as to the defendant's subjective knowledge. And I would point...
How could it be harmless? I mean, he says the standard should be, the test is whether or not it's outside the bounds of her medical practice. It seems to me if he's right, I have a hard time, understanding how it's harmless. I mean, you got a whole bunch of evidence that it was outside the course of the ordinary, medical practice. But if he's right, that's not the test at all. It's whether whether it was outside the bounds of her medical practice. It seems, I'm not saying that's the right view, but it seems like maybe I'm not understanding that right. It seems like harmlessness would be a tough argument.
Well, I think that you have to, if you believe that the pronoun her should have been included, then we're really only talking about the differences
So
words across.
that one word change, several places might be harmless. I'm going with the theory that goes along with it. I think I understand what you're saying.
Right, because, just to make sure I understand your position, I mean, if your colleague is right about this, all the evidence that you put on, for harmless error purposes, you put on a significant amount of evidence that her ordinary business practice, her ordinary medical practice, was to effectively be a drug dealer. And so, if she was being a drug dealer, she was being a drug dealer. Like, that is wholly consistent with her ordinary medical practice, which was being a drug dealer. And so if your colleague is right, that so long as she was acting subjectively in accord with her own drug dealing practice by dealing drugs, it wouldn't be harmless, right? Because it's in fact exactly what you've proved. You proved that she's operating a medical practice that is a drug dealer.
Yes, Your Honor, we did prove beyond a reasonable doubt that the defendant was a drug dealer. I will note that part of her medical practice was having patients sign a contract that stated her policies, which she herself did not enforce. So even if the defendant's theory that that any doctor whose business model is a drug dealer, like this one, acts consistently across all patients, she did not act consistently with how she advertised her practice, as evidenced by the fact that she made statements to the Board of Medicine that I'm going to do this. I understand that I need to enforce these policies. I'm going to do them. I'm going to have all my patients sign these policies that are to enforce within my practice, and then didn't do them. So she herself did not act consistently with what she held her her professional practice out to be, assuming my colleague is correct.
No, I'm fine, thank you.
Thank you,
Your Honor.
counsel.
We ask that the court affirm.
Your Honor, let me address the last point as to whether Dr. Ball was the quintessential drug dealer. Dr. Ball had a practice, Your Honors, of about 70 to 75 patients.
But your theory, just to make sure
Yes.
I understand it, your
Yes, Your Honor.
theory is, accept it as a hypothetical, right? I know you want to fight on the facts, but accept it as a hypothetical, that if you have a doctor whose entire medical practice is to prescribe drugs for addicts, like, just assume hypothetically, this is not necessarily this case, that's their entire practice, is to prescribe drugs for known addicts, and to get paid as a result of it. It seems like to me, your theory is that that person would subjectively believe that they were acting within their own medical practice, that is, being a drug dealer. And so that person, under your theory, is not guilty.
No,
Am
that's
I
not
right
right.
about that?
No.
Tell me why that your theory doesn't go that far, because it seems like that's what you're saying.
It goes to what Justice Alito said in his concurrence. If you're issuing a prescription that is not a valid means of pursuing a medical purpose.
I understand. Listen,
Oh.
I can read Justice
Okay.
Alito as well as you can, right?
Yes, yes,
so
Your
what
Honor.
I'm asking is why your theory, right, that is the person's idiosyncratic medical practice that matters. If the idiosyncratic medical practice is being a drug dealer, and they act consistent with that subjectively, I intend to be a drug dealer.
Oh.
I intend to sell
Yes.
drugs. And my entire medical practice is to sell drugs. Like, I'm a drug dealer, it's turtles all the way down, right? Like, I'm a drug dealer at every possible mental state and objective action. I think, under your view, she is acting consistent in that scenario with her medical practice, as you're trying to have it defined. Tell me why that's wrong.
If your hypothetical is the doctor knows that they are issuing prescriptions for either diversion or to maintain a drug habit, and all they want to do is make money, they're a criminal. I totally agree.
And why so maybe you... well,
That's not our case.
No, but tell me why you think they're a criminal? Why do they, particularly on the prong that we're talking about, medical practice?
Yes.
Right? Why are they guilty under the medical practice piece of this?
Because they don't have a subjective good faith belief that the prescriptions they're issuing are for a valid medical purpose.
Okay, so it's only that. So they may fail there, but you would say that in that instance, they are acting consistent with her own medical drug dealing practice. So the second piece, in that scenario, you would think the government can't prove that piece of the test.
I respectfully disagree. It wouldn't be a medical practice. It'd be a drug enterprise. I respectfully disagree with the assumption. If you're a drug dealer,
So then,
if you're a
okay,
doc-
why is it not a medical practice? Are you looking at some objective standard of a medical practice? I thought you've been telling us that we're just looking at her subjective understanding of her medical practice. And so what's the objective standard that you tell me that what she's doing is not a medical practice?
I will talk about Dr. Ball's practice.
No, but I want to know the
Yeah.
theory. What is the objective standard that you're measuring my hypothetical against to say that's not a medical practice?
Because the doctor in your hypothetical, Your Honor, is admittedly issuing prescriptions not for a valid, legitimate medical purpose, is issuing prescriptions to pursue drug deals, to maintain an addiction, or for diversion and selling. That's not a medical practice, that's a drug enterprise.
And you say
Under
that...
under the cloak of a doctor.
And you say that because you have some objective understanding of what medical practice means.
That's correct,
Yeah.
yes. But in this case, I just want to focus on who Dr. Ball was. She had 75 patients, only about 33 were narcotics, and of the 33, only 27 received drugs, 6 did not. And I want to compare, last point on this, Your Honor, is I want to compare this case, Dr. Ball's case, to United States versus Holschuls of the Seventh Circuit. In that case, it was a nurse practitioner. She had waiting lists of patients. She had lines of patients at the door when she's opening. She had nurses that quit because she was going to fire them if they didn't do the wrong thing. How much did she make a year? She made $1 million over 2 years. Dr. Ball, and this is in the record, Dr. Ball had an idiosyncratic, unique practice in her home. She made, after taxes, $19,000 a year.
Probably would have made less if she wasn't dealing drugs. Thank you, counsel.
Thank you, Your Honor.
We'll adjourn court for the day. Sonny Dow.